The insurance adjuster who calls you after your car accident sounds so friendly, helpful, so concerned about your well being. But what they won't tell you is they're trained professionals whose job is to pay you as little as possible. In this video, I'll show you the 5 most common tactics insurance companies use to limit your settlement and exactly what you can do to protect yourself. Hi, I'm Carl Truman. As a retired United States Army officer and attorney, for over 30 plus years, I've helped thousands of people across Kentucky and Indiana win fair compensation after serious injuries. If you or someone you love has been hurt, don't face the insurance companies alone. Call me at 502-222-2222 and you can count on the Colonel. Let me walk you through what happens behind the scenes after a Kentucky or Indiana car crash and how to protect yourself before the insurance company turns your claim into a bargain. The first tactic is the quick settlement call. It usually happens fast. You're still dealing with the shock of the wreck. You may not even have seen a doctor yet, and the adjuster reaches out, sounding friendly and efficient. They'll say they want to, quote, take care of this, and they'll put a number on the table that feels like relief. The problem is, early offers are often based on one assumption. You don't know how bad the injury is or how bad it's going to be yet. Many common car crash injuries don't fully show up right away. The stiffness can turn into real pain. The headaches can become daily. The back issues that felt minor can start affecting your work and sleep. Once you take the money and sign the release, the claim is over. So the simple rule is don't settle until you understand your medical situation and that you've had enough time to see what recovery really looks like. The second tactic is the recorded statement trap. The adjuster will frame it like a formality. We just need your side of the story for our file. But what they're really doing is locking you into a version of events they can use later. They're listening for uncertainty, guesses, or anything that sounds like partial fault. A phrase like, well, I didn't really see them, can get twisted into being inattentive. A guess like, maybe the light was changing, can get used to argue you share blame. Even a harmless comment like, I'm doing a little better today, can be seen as downplaying symptoms to be resolved. The safest approach is to avoid guessing. If you don't know, say you don't know. If you don't remember, say you don't remember. And if you're uncomfortable with a recorded statement, it's okay to insist on a written communication so you have a clean record of what was said. The third tactic is downplaying your injuries. Adjusters use language that sounds medical, but it's really negotiation language. The danger is it makes you second guess your own experience. You start thinking like you shouldn't complain, or you should tough it out, or you should just get over with it. But pain is not a personality flaw. If the injury is affecting your sleep, work, driving, basic daily tasks, that matters. The way you protect yourself here is straightforward. Follow your doctor's advice. Keep your appointments. Be honest about your symptoms. Make sure your limitations are being documented, not just said out loud to friends and family. Insurance companies respect medical records more than conversations. The fourth tactic is delay and stonewalling. This is where claims go quiet for weeks, then months. You submit what they ask for, then they ask again. You call and get, we're still reviewing. You're told it's been reassigned. You're told they need one more item. Sometimes delay is just disorganization, but sometimes it's a strategy. Delays create pressure. Bills stack up, work gets missed, stress climbs, and when someone is under pressure, a low ball offer starts to feel like the only way to breathe again. That's why staying organized matters. Keep track of what you sent and when. Follow up in writing. Don't let the claim drift when deadlines get closer. Timing affects leverage, and insurance companies know that. The fifth tactic is comparative fault. Even when the other driver caused the crash, the insurance company is often trying to find a way to assign a percentage of fault to you. Maybe they'll argue you should have reacted differently, you were going too fast for the conditions, you could have avoided the impact. The reason they do this is simple. If they can place even a small amount of fault on you, it reduces what they have to pay. That's why it's so important not to casually admit fault, apologize in a way that sounds like responsibility, or speculate about what you, quote, should have done or could have done. Let the facts speak for themselves. Your job is not to narrate the accident like a referee. Your job is to be accurate and consistent. Now, I want to say something clearly. The best defense against these tactics is being consistent, not rushing to decisions before you have the full picture. If you've been injured in a car crash in Kentucky or Indiana, and you're dealing with an insurance company that's stalling, downplaying your injuries, or pressuring you to settle quickly, call us at 502-222-2222 for a free consultation. We'll review your case, tell you what it's really worth, and help you stand up to the insurance company. You pay nothing unless we win. And if you want to learn the exact steps to maximize your settlement, watch this next video where I break down what you need to do after a crash in Kentucky or Indiana to protect your case from day one.